All right. We should be live. We're going to double check to see if we are, in fact, live. Live. All right. This shows that I'm live. All right. So, good morning, good evening, good afternoon to you. Let's see if audio is coming through. All right. So, audio is coming through. Phenomenal. So, I'm going to close that. As Firemoth states in the chat, there is a link that is pinned. If you're dumb and you want to come up here and argue with me, you're more than welcome to. There's the one rule that you have to show your face. If there are Lane Meyer supporters in here who think that they know the law better than me, or they're smarter, prettier, got a bigger dick, whatever, doesn't really matter to me. Link is there. Link is always there in all of my live streams because, well, a lot of people like to talk a lot of shit in the comments by dropping little written comments when they don't have anything at stake. And that's all fine and dandy like sour candy. But why don't you put your face where your mouth is? Let the world see how stupid you really are, because I assure you I will show you how stupid you really are. Now, I have taken the time this time to no, tomatoes. I will not insult you without you joining. I have taken the time to redact this version, this one. There's an unredacted copy on my Discord. So if you really actually want to get in there and see the redacted stuff, I assure you I'm not hiding anything. It's there for you. But before we get into this motion, I want to read two paragraphs from two Arizona Supreme Court cases, because I figure it will help us if we understand ahead of time basically what Lane Myers is up against. The first one is State versus Shackart, a 1997 Arizona Supreme Court case. Before we jump into it, there is this. The termination of a Rule 10.1 motion lies within the discretion of the trial judge. We will not interfere absent an affirmative showing of an affirmative, or the termination of 10.1 motion lies within the discretion of the trial judge, and we will not interfere absent an affirmative showing of abuse. There was there's this language, and then there's other language about the chief judge, presiding judge, ruling on these. I believe the distinction is that they won't continue a trial if at trial you find out that you're going to have Joe Blow as your judge. They're not going to continue the trial, so you could file a motion to recuse Joe Blow. You'd actually have to make your motion to Joe Blow, and Joe Blow gets to decide whether or not you want to, or whether or not he wants to grant the motion. If he grants the motion, well, then he kicks you down the road to another judge to be heard. But if he denies the motion, then it's just an issue for appeal. Now, in Lane Meyer's case, where he's not in front of the trial judge yet, although apparently Metcalf will be doing the trial, since he's not in front of the trial judge yet, and since there's time, then he can file his motion and have the judge recused. Now, that wasn't really what I was pulling this one up for. It's this language here. Defendant's other complaints relate to a myriad of remarks and insinuations allegedly directed against him, as well as rulings made during various phases of the proceedings. We note first, the disagreements over rulings are insufficient to support a recusal motion. So every time that Lane Myers suggests that a ruling that Metcalf made is evidence of bias, you could just completely throw that out. Sorry. If you disagree with the ruling of a judge, your remedy is not to get him recused for bias. It's to appeal the issue. It's to file a special action, which in Arizona is, I think, their equivalent of a petition for a writ of mandate or a writ of prohibition, something along those lines. So just note that anytime anybody says this judge is biased because he ruled against me, wrong answer. Sorry. Even if he did rule against you, it's not bias. Just so we're clear. Further, opinions formed by the judge on the basis of facts introduced or events occurring in the course of the current proceedings or prior proceedings do not constitute bias or impartiality unless they display deep-seated favoritism or antagonism. The incident cited by the defendant show neither an extrajudicial source of bias or any deep-seated favoritism. So really what you're looking for to get a judge recused, really what you're looking for is you're looking for some sort of outside thing. Like if opposing counsel is the judge's daughter, well, he's more likely to rule in her favor. That's something that, that's bias. If he has dinner every other night with the prosecutor, it's outside stuff that is much more likely to get it. The other case is State versus Henry. It's a 1997 Arizona Supreme Court case. Both of these are Arizona Supreme Court cases, and they both cite Light Key versus the United States, which is obviously United States Supreme Court case. So all of this stuff is founded on very secure case law. But Henry says the trial judge is presumed to be free from bias. Opinions formed by the judge on the basis of facts introduced or events occurring in the course of the current proceedings or of prior proceedings do not constitute a basis for bias or partiality motion unless they display a deep-seated favoritism or antagonism that would make fair judgment impossible. So, two things to note from this. This is the more expanded version of the quote that was given in Shackert. Number one is events occurring in the course of the current proceedings are a permissible source for opinions formed by the judge. So if you walk in to his courtroom, the judge's courtroom, and you're an asshole to the judge and you're an asshole to opposing counsel, and you make a fuss, you make a stink, you make noise, you generally present yourself as a giant fucking turd, well, that is an event occurring in the course of the current proceeding. That is something that the judge can, will, and should form an opinion about you on. And the only way that opinion is going to be something that would give grounds for a recusal motion is if it's such a deep-seated favoritism or antagonism that it would make fair judgment impossible. It has to make fair judgment impossible. Not hard, but impossible. The trial court's refusal to examine photographs, if true, would not alone demonstrate such profound antagonism. They need profound antagonism. Disagreements over rulings insufficient to support recusal. Again, additionally, defendant's subjective observations of the judge's tone of voice and expressions would add little, if anything, to his claim. And then italicized, not establishing bias or partiality, however, are expressions of impatience, dissatisfaction, annoyance, and even anger that are within the bounds of what imperfect men and women sometimes display. Thus, even assuming defendant's unsubstantiated claims are accurate and that he had a right to testify, blah, 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 we find no prejudice. So what this is pointing out is that if you act an ass to the judge, and if you show a lack of decorum, and if you argue with the judge, and if you make ultimatums with the judge, and if you threaten the judge, well, if the judge gets a little peeved at you, that's not a basis for recusing the judge. Sorry, not sorry. Somebody asked a question. In your experience, how often have these motions to recuse a judge ever been successful? From what I've seen, judges are more likely to recuse themselves. So I have never attempted to recuse a judge, nor have I seen a judge get recused in a criminal case. The only time I have recused judges, it has been on California, the civil peremptory challenge for a judge. I don't know if it's the same for criminal, but the judges are, if you do the peremptory challenge, in my experience, the judges are very likely just to be like, you know what, not worth my time, not worth my trouble. Peace out. See ya. Wouldn't want to be ya. I've even seen them filed improperly, because in California, you're supposed to file the motion in person, even in places where normally you can file electronically, at least in my area. You always have to file it in person at the courthouse, and you have to mark it as for the presiding judge. And so it gets routed differently. And even when I have seen them filed improperly, where it actually gets rejected, because placer court, you can see documents have been rejected. I've still seen it get grant, or I've still seen the judge recuse himself on the basis of that. So, believe it or not, judges don't want to waste their time. A lot of judges would prefer to do a good job and give good results and get overturned less on appeal. Just because they get overturned on appeal doesn't mean that they're bad judges. Everybody makes mistakes. Everybody gets things wrong. And sometimes there's questions of law that are just a little bit vague. And so, but a lot of judges with aspirations of moving up and becoming courts of appeals justices, etc., want to be overturned less, have a better track rate of having their decisions upheld. So there you go. All right. So here's his motion to change judge rule 10.1. Defendant moves this court pursuant to rule 10.1 to change defendant's judge for cause. Defendant files this motion because Judge Metcalf has shown he is not capable of guaranteeing Mr. Myers has his right to a fair and impartial trial, free of bias and prejudice from the trial court. Now, just remember that what Mr. Myers has to do, what defendant has to do, is show that the bias exhibited by Metcalf makes a fair trial impossible. And I believe he has to show that by a preponderance of the evidence. So even the standard that he's marching out the gate with is the wrong standard. You just saw me read it. That's not the standard the court of, or the presiding judge is going to apply. So there you go. You're already batting a big fat zero. In such a high profile case, involving a journalist exposing public corruption at Pima County Superior Court, any appearance of impropriety, bias, prejudice, and lack of impartiality that erodes public trust in the Pima County Superior Court is magnified 1,000 times more due to the outstanding public interest in defendant's unlawful arrest and imprisonment. Wow. Those are awesome claims that this entire sentence or paragraph is just one sentence. Phenomenal. Just one sentence. So that's great. It's great. A one sentence paragraph. We're doing great. But even better, it is completely it's garbage. There's nothing in there of any import to the court. Just because the news is interested in it. And the news is interested in it because Big Jim Finch, he's reporting on it. He has reporters there. So there you go. So it is a high profile case, maybe for Pima County or something. I don't know, but it's interesting, and the public is interested in it. I mean, you idiots are here. You idiots are here listening to me talk about it. So there you go. But this is just garbage. This is not a legal argument. The following memorandum of points and authorities, along with included affidavit, will outline the concrete facts and specific allegations detailing why Judge Metcalf must be removed from this case for cause. Number one, relevant factual and procedural history. I'm sure there's going to be actual facts in here and probably very little procedural history. No, there's going to be no facts. No relevant facts anyway. Mr. Myers is being unlawful. Why doesn't he just say I? Like, you're handwriting it, bro. Like, where's this need for formality? You are the defendant, and you are pro se. You're not talking for someone else. You're talking for yourself. You are representing yourself in handwriting. Let's drop a little bit of the formality. Just say, I am being unlawfully prosecuted. I mean, it's still a meaningless sentence because, well, that hasn't been proven. And the presiding judge isn't going to make a decision on whether or not you're being unlawfully prosecuted. That's something a completely different court will make, if that's a decision a completely different court will make, if a completely different court ever even has to make that decision. But he says, I'm being unlawfully prosecuted and held in jail with no bail for exposing judges. No, you're being held in jail for committing or for proof evident or presumption great that you committed felonies while out on bail for felonies. That's why you're being held in jail with no bail. And prosecutors in Pima County for their unlawful actions in their capacity as public officials. It's not the things I'm actually charged with are why I'm in here. It's the things that I'm not charged with. Sure, that happens. That makes sense. 4 of Mr. Myers' felonies are for exposing Pima Superior Court judges Don Weiland and Don Walton for their unlawful actions in ex parte injunction hearings on behalf of a state of Arizona employee married to the prosecutor. So making videos about court cases are not why people get felonies. Like, I'm not going to catch a felony for this. Believe it or not, me going over this case is not going to give me a felony because I am not harassing anybody. And no reasonable person would think I'm harassing anybody. And yet, a reasonable person and judges have come to the conclusion that there is at least a preponderance of evidence, if not proof evident and presumption great, that what you're doing, Mr. Myers, is a felony. And it's for what you're doing. It's for what you're doing to the state of Arizona employee that's married to the prosecutor, to a prosecutor. And he really should identify that it's not the prosecutor in this case, although that'd be some sweet lesbian action. Hell yeah, brother. Hell yeah. The public's trust of Pima Superior Court is at an all-time low, citation needed, due to the exposure by Mr. Myers' investigative journalism. Somehow I doubt that. Judge Metcalf is continuing the very same patterns and practices that Mr. Myers has spent the last 9 months exposing, leading to these baseless charges. Isn't it weird? Isn't it odd? Isn't it crazy that every single judge that Myers gets in front of shits down his back? You know, it's crazy. What are the odds that every single judge that Myers gets in front of is just prejudiced against him, is just, bought and paid for by the Tucson City prosecutor or something? Because when the presiding judge denies his motion for recusing Metcalf, when the presiding judge does that, is he going to be like, man, the presiding judge is also biased and what are all the adjectives he used? Doing unlawful actions in her capacity as a public official, because the presiding judge is a female. So that's why I use the female there. Now, Mr. Myers is being denied a fair and impartial trial. You haven't even been set for trial yet, Broseph. Due process, I defy you to show me a due process violation. Speedy trial, the time for speedy trial hasn't passed yet and has now been threatened by Judge Metcalf. Oh, I can't wait to see what the threat is. I can't wait. I have not actually read this, believe it or not. I anticipated where it would go from reading the first paragraph, but I have not read this, just so you know. He hasn't made a single legal argument yet, by the way, just so you know. he's thrown language that he's seen in statutes and case law, I'm assuming, into here, but he has not actually like made a legal argument yet. The court must immediately remove Judge Metcalf from this case to guarantee Mr. Myers a fair and speedy trial free of bias and prejudice. We're almost done with page 2 and still haven't seen a damn bit of legal argument or relevant facts. Here we go. March 19th. Media request hearing. Metcalf denies 122C and 122H. 122H is not for debate. 122H is not for debate. Hold on. We're getting to the Googles. Hold on a second. What's that? 122H. 122H. And 122C. Help me out, chat. Help me out. Anybody know what a 122H and a 122C is? Recording? That recording? 122H recording? Arizona Supreme Court Rule 122H. I remember this. Okay. Personal audio recorders. Record notice to the court. A person may use a personal audio recorder during a proceeding, but the person must notify the judge or the judge staff prior to using the device. The person who uses a personal audio recorder is not required to submit a request under paragraph C of this rule, but a person who wishes to record or broadcast the audio portion of a recording of the proceeding with a device that is not on the person must do so. The use of personal audio recorder must not be obtrusive, distracting, or otherwise prohibited, and the use is subject to the prohibitions of paragraph K of this rule. So here's some fun language for you. It cannot be otherwise prohibited. Cannot be otherwise prohibited. So on March 19th, media request hearing, Metcalf denies 122C and 122H. 122H is not up for debate. 122H absolutely is up for debate. Because this otherwise prohibited is just a de facto showing that it can be prohibited. And of course it could be prohibited because the court's primary, like, overarching, like, the number one rule is it's trying to give a fair trial. That's like the general thrust of everything. And if allowing someone to record would impact the ability to have a fair trial, then the court can take that away, right? And then C was request to cover proceeding. This was for the C was for media coverage. And media coverage, the court can grant it or deny it. That's Chandler, United States Supreme Court case Chandler versus Florida, and also Estes versus Texas. So going back to this, 2 issues. Number 1, you have to bring your motion for recusal within 10 days of learning of the bias. That's issue number 1. Issue number 2 is he's quibbling with the ruling. And once again, that is absolutely not a basis. So he misses on the 10 days, and he misses on the 10 days, and he misses on the requirement that it has to be or the restriction that it can't be for he made a judgment or he made an order that I disagree with. March 20th, the Feretta hearing. Metcalf denies 122H and complains that people calling his chambers to protest his denial of 122H is harassment. Okay, 2 things there. Number 1, again, you missed because of time, and him being annoyed about people calling his chambers doesn't mean you can't get a fair trial. Remember, his annoyance over shit that's happening in the proceedings, not. Oh, yes. I'm sorry. Thank you for reminding me, Alpha Fox Adam. Go to BetterHelp, go to NordVPN, go to Factor, go to Raid Shadow Legends, and go to Manscaped. Links are in the description. Click on the links, use the links, and then put in code MERB 34th Street, and you get 0% off your first order. So thank you for reminding me, Alpha Fox Adam. All proceeds go to nowhere because there are none. So again, we're blocked out on time. We're blocked out on the order, and his annoyance is something that happened during the proceeding. It's directly related to the proceeding, and it is not going to be sufficient. March 26th, 25th, and 26th, no bail hearing. Judge Miller allows 122H recording. What does that have to do with the price of rice in China? Don't know. Some other judge made a different order. Well, congratulations. March 25th, Metcalf issues order banning all media coverage throughout the entire case. Somehow, I doubt that Judge Metcalf banned all media coverage. What I am going to guess is that he banned all broadcasting and he banned all recording. But media is allowed to attend. Big Jim Finch has had reporters there at every hearing that I'm aware of. Media is there, bro. Media is there. These hearings aren't private. And for the slow boys out there, the court broadcasts it on its YouTube channel. That's how retarded prophet, what's his name? Something prophet, R prophet. It's something. I went to retarded just because of who he is, but whatever the guy's name. The prophet dude. Hey, Bun Bun. There's a bunny out here. Bye-bye, Bun Bun. And then Big Jim Finch streams it, right? And then I don't believe. No, I did not stream it because I wouldn't do that. But I've watched that. I've watched it anyway. So I'm sure other people are streaming it, recording it, and streaming it too. There's that other guy, the guy out of Florida that got convicted with Metcalf, not Metcalf, with George Metz. The guy's name is like Joshua Gray. Foshin. Yeah, that's something like that. I think his name's like Joshua Gray. I think he goes by Captain Awesome when he gets arrested by police or something like that. So just gay. So I don't even know where I was going. But anyway, so it's being streamed. Reporters can go there and report on it. On April 4th, a motion for bail reexamination is filed. Congratulations. Once again, if that was your evidence of an issue, you'd have to have filed this motion by the 14th, and you filed it by April 14th, and you filed it on May 16th, so you missed it by a long shot. April 15th, the pretrial is held and Judge McDonald presiding. McDonald allows 122H recording. Court security closes court. Well, that's not so. Okay, so if the court security closed the court, who cares? It's not Jeff Gray. Jeff Gray is honor your oath. It's some other guy, Gray. It's like Joshua Gray or something like that. Yes, this is a public service. And yes, it was Joshua Gray. Yeah, this is a public service is Joshua Gray. And I'm sorry that he creeps you out, Bev. So what Judge McDonald did, nothing to do with Metcalf. This is completely extraneous. April 21st, media request hearing. So the media requests a hearing. Okay. So Metcalf denies all media coverage. Who cares? Again, this is an order. This is not basis for bias. Metcalf says media coverage would just cause chaos and that the press can file a special action. Yes, and that is the appropriate course of events for the press to take. The press can file what in California would be a petition for writ of mandate or whatever, or something to get in there. That's the court gave the right. Yes, if you don't like my judgment, if you don't like my ruling, if you don't like my order, Go file a special action. That's the appropriate thing to do. April 28th, Friday hearing. Court security doesn't allow media into the courtroom. Bail motion is withdrawn. Okay. Again, if it's the court security doesn't allow it, well, then that's not the judge. If it's the judge made an order closing the courtroom, well, then that's not basis for bias, because once again, that would be a court order. And anyway, you slice it, you still missed it, because April 28th, you'd have till roughly May 8th, roughly. May 12th, pretrial. Ooh, Lord have mercy. We're finally in the territory that it would be allowed. Metcalf sets a trial date that doesn't allow Mr. Myers time to be sentenced within 150 days speedy trial. Well, okay, then you would get to file an appeal based on a violation of speedy trial. But just because there is a court date set now doesn't mean that that's going to be the actual trial date that you're going to have, number one. And number two, I believe the court was very insistent that the trial had to start within the 150 days, not that sentencing had to be finished within 150 days. And that seems appropriate, that the trial has to start within 150 days, because you never know how long a trial, especially a criminal trial, is going to go. So if they start the trial on day 140, and then the defendant just drags his feet and slow rolls and takes 10 hours to question each witness, then what? Then all of a sudden the state's gonna have to drop the case because speedy trial? Does that make sense to anybody? Doesn't make sense to me. I strongly suspect that it has to be started within 150 days, and not that it has to be completed within 150 days. Because you could guarantee a start date, basically. Well, even then, that 150 days is subject to exceptions. If there's good cause why it gets kicked out, like if the defendant fucks around and asks for continuances and this and that and the next thing, and files a shit ton of useless motions, that might be grounds for having it kicked out. So there you go. Metcalf threatens Mr. Myers with retaliation if he files a judicial conduct complaint. I didn't hear that. The fun thing is that the presiding judge has ordered a transcript of the hearing, at least of this hearing, the pretrial hearing. Let me double check that. Curated docs and criminal notice, and share this tab instead. So yeah. So this said it was set for Tuesday, June 10th. It seems reasonable that it would be heard on Tuesday, June 10th. But anyway. So going back to this tab right here. So I doubt seriously Metcalf threatened Myers with retaliation if Myers filed a judicial conduct complaint. I seriously doubt that. I listened to the stream. I would have remarked that would be not that would not necessarily be. I mean, it depends on what retaliation was threatened. So I don't know what they do, but I just don't think it's a violation of speedy trial to have the trial still underway when the 150 days passes. Bail reexamination motion is refiled. Metcalf refuses to set evidentiary hearing within, I'm going to assume that's 7 days. But again, that's an order issue, and again, that's not bias. He still hasn't alleged any actionable bias. He hasn't alleged any. I mean, I understand that he feels like the judge is biased against him because he's not getting his way. But this isn't, none of this is bias. None of it is. Argument. A party challenging a trial judge's impartiality must overcome a strong presumption that trial judges are free of bias and prejudice. Yes. Yes, that is the case. Overcoming this burden means proving, quote, hostile feelings or spirit of ill will or undue favoritism towards one of the litigants. In 24 Arizona App 148. Case law, select courts, Arizona. And I've already forgotten it. It is 24 Arizona App, Arizona App 148. 24 Ariz App 148. Guardianship of Steyer. Oh, well, would you look at this? Civ? This is a civil case? Guardian of the estate? This would be handled in probate court, which would be under civil, but sometimes they get their own case numbers. So this would not be under Rules of Criminal Procedure 10.1 because this is a civil case. So why are you citing a civil case in a criminal action? Duh. Every time I hear Lane Myers fans, talk to me about how smart Lane Myers is, I'm just like, wow, how fucking retarded are you that you're so stupid that you can't see how stupid Lane Myers is? Amazing. It's fucking amazing. The right to a fair trial is a foundation stone upon which our present judicial system rests. Necessarily included in this right is the right to have the trial presided over by a judge who is completely impartial and free of bias or prejudice. Oh, look, it's an older case, 1967. What do you think is more controlling, a 1997 case or a 1967 case? Especially when Light Key, the Supreme Court case Light Key, came out in 1994. Maybe there's a plea deal underway. Maybe, I don't know. Mr. Myers believes even Ray Charles can see the biased and prejudicial decisions and actions by Judge Metcalf in this case. Nope, haven't shown any. Literally have shown none, at least none that are actionable. Are you, Lane Myers, prejudicing Metcalf against you? Yes. Is it actionable? No. Has it met your goal of saying that he's incapable of giving you an impartial trial? No. So, sorry. As Mr. Myers will show below, Judge Metcalf is embarrassing himself. Is he, though? In the entire Pima County Superior Court with his intentional, I think that's supposed to be intentional, disregard for clearly established laws and rules of procedure, clearly threatening a defendant for filing a complaint with the Judicial Conduct Commission shows a clear retaliatory animus by Judge Metcalf. Well, how about this? How about it is an attempt to improperly influence the judge by threatening the judge with filing a Judicial Conduct Commission because you don't like what the judge is ordering? How about that shit? Although I seriously doubt that Metcalf threatened him. Clearly. Denial of media coverage. Again, these are all going to be orders, so they don't matter. Article 2, Section 11 of Arizona Constitution provides that justice in all cases shall be administered openly and without unnecessary delay. Need I remind you that number one, the courtroom is open, at least Metcalf, I don't believe, has closed it. And number two, it's broadcast on YouTube for anybody with an internet connection and a device to watch. How much more openly can Metcalf be administering justice? I don't know. Article 2, Section 24 of Arizona Constitution provides that, quote, the accused shall have the right to appear and defend in person to have a speedy public trial by an impartial jury. Well, okay. So trial hasn't happened yet. I don't know why. What's the fucking argument here? Trial hasn't happened yet. Like, I'm sure that at trial you'll get to appear in person. I mean, unless you shit the bed so hard that the judge has to remove you from the room because you're just not allowing proceedings to continue. But like, you're not at trial yet, homeboy. I don't know what to tell you. Rule 9.3 of the Arizona Rules of Procedure provides all proceedings must be open to the public, including news media representatives, unless the court finds on its own motion or on a motion or on its own motion that open proceeding presents a clear and present danger to the defendant's right to a fair trial. Okay. All right. So, number one, Metcalf, nowhere in the allegations did Metcalf close the courtroom, did he? So McDonald closed the courtroom. And at the April 20th Ferretta hearing, he says court security doesn't allow media into the courtroom. I don't know exactly what that means. Again, he hasn't alleged that was Metcalf doing that. He's alleged court security did it. So, but then the court can find on its own motion that it needs to close the proceedings. Like, again, what's the problem? And if the court finds on its own motion that the proceedings should be closed, that's not something you can recuse the judge over. That's something you'd have to appeal or do a special action. By banning media coverage against the objection of Mr. Myers shows clear favoritism to the state in this proceeding. Nope. No, it doesn't. Sorry. Mr. Myers is demanding that the media be allowed to cover and document his public trial. Yet Judge Metcalf, for some unexplainable reason that he's explained in open court, Judge Metcalf likes to explain why he's doing what he's doing, and Myers' inability to pay attention is Myers' problem, not everybody else's. I am sure Judge Metcalf explained in exhausting detail why he wouldn't allow public recording. I didn't watch those videos, but I am about as sure as I could be without having witnessed it myself that he definitely would have explained it. Has decided to unilaterally ban all media coverage. Yeah, judges do things unilaterally. That's like literally the way judges do it. There is no other way for a judge to do it unless it's like a panel of judges, in which case they'd have to, agree with other judges. But if it's just one judge sitting on a trial or on a motion hearing, then that one judge must, needs, necessarily, by definition, do things unilaterally. He doesn't have to like do what you want. He doesn't have to partner with you, Lane, you fucking ignoramus. This is also a violation of Article 2, Section 6 of the Arizona Constitution, which guarantees a right to the free press. Well, Metcalf has already said, if you're the press and you want to record this in the courtroom, great, file a special action. File a special action. That'd be the free press bringing it, not you. If the defendant is demanding the media be allowed to cover his case, then there is no prejudice against the defendant by allowing it. Well, no. First of all, there may still be prejudice to the defendant. If you're not able to get an impartial jury in there and you get convicted, and you're not able to get an impartial jury based on your own actions, and you get convicted, and then you appeal, you can appeal that you didn't get an impartial jury because they were all tainted. And you may prevail on that appeal. So no, just because you're agreeing that media be allowed to cover your case, you're not agreeing. Did I just fart? No. But I mean, if you want to think I did, sure. I fart a lot, and you can't smell it. So why would you even care if I did? But it wasn't. Sorry, Rosewater. I know maybe that's your fetish or something. But anyway, back to the important stuff. Just because you're agreeing to the media being present doesn't mean you're agreeing to it. Doesn't mean you're agreeing to a biased trial. So he's mixing terms. He's misunderstanding what he's agreeing to. The state is not facing prison time, so they have no argument against allowing media coverage. Yes, they do. The state has just as much right to a fair trial as you do. Like, if the judge was biased against the prosecutor, the prosecutor could move to have the judge recused. If the prosecutor rolls into court with his charges against Joe Bob, and he looks and he sees that Joe Bob Sr. is the judge and Joe Bob Jr. is the defendant, the prosecutor can move to recuse the judge. The victim is not allowed to be filmed pursuant to Rule 122C, so there's no excuse for banning media coverage. Well, there is an excuse, first of all, but even if there wasn't an excuse, judges don't need excuses, but even if there wasn't an excuse, this is still file special action. Number 2, a violation of Admin Order 2024-47 and Rule 2022H. Admin Order 2024-47. I'm sure it's Pima County Superior Court Admin Order 2024 what was it? 47? 47. Right there. Any use of, can I highlight it? I can't highlight it. Any use of portable electronic devices, photography, audio recording, or video recording in a courthouse is subject to the authority of any judge, court administrator, or court security officer to limit or terminate the activity that may be disruptive to court operation, may affect the fair administration of justice, or that may compromise courthouse security. I need to get some more water. I will be right back. All right. It's not bourbon, but it'll have to do. All right. So where were we? Yeah. So any judge can limit the recording. Yeah, so it says right there on number 6 that the judge can limit the recording. So if the judge limits the recording, then it's not a violation of the rule. So I don't know what the F he's talking about. Rule 122H provides a person may use a personal audio recorder during a proceeding, but a person must notify judge or judge staff prior to using the device. A person who uses a personal audio recorder is not required to submit a request under paragraph C of this rule. Yeah. Does it say anything else? Does it say anything else, Lane? Does it say anything else, Lane? Does it say that that you can use it unless it must not be obtrusive, distracting, or otherwise prohibited? If it is otherwise prohibited, you can't use it. So why did you leave that part out, Lane? Why didn't you cite the entire rule? Isn't it crazy that he just left off part of the rule? Like, I don't know, the presiding judge of that fucking courthouse wouldn't know what the whole rule is, especially considering the admin rule that judge probably. Oh, hey, look, Danelle B. Lusky is the presiding judge who signed the fucking rule, the local rule. That references exactly how 122 is supposed to be dealt with. That specifically allows for judges to make orders that say you can't use it. And I closed it already, but let's see if I have. Let's see if I go to downloads and I go to this one. And we go to this tab. And look, there's the Honorable Danelle B. Lusky, the judge that's going to be reviewing and making a decision on Lane's motion. So the odds of success just keep plummeting there, Lane. Just keep plummeting. Jesus, ever-loving Christ. I apologize for my blasphemy there. He says Rule 122H is not something that can be denied unless it's disruptive, in which case you would need a citation to some sort of an authority for that assertion. There is no citation to any authority for that assertion, so the court can literally just ignore it. The court can be like, well, that's not something that I need to be aware of because you're making an assertion without any support whatsoever. He said, he continues, by banning it ahead of time without any disruptive behavior is completely biased and prejudicial. No, sorry, don't think so. There were issues already, I believe, from the get in this case. Things were showing up on the interwebs, and yeah. It might be Tucson City. I know, like Tuck, the big guy who pissed himself when he got tased in Texas. I know him, and was that guy's name Stinky? And I mean, I know they would always be in that Tucson City courthouse. If the press reads the rule and shows up and wants to follow the rules, Judge Metcalf has already taken away that right ahead of time. Well, yeah, I mean, that's what happens. If the judge says there's going to be no broadcasting of this case other than what the court already does. Oh, baby bun. There's baby bunnies around here. So yeah. But if the press has an issue, then the press can file special action. Again, The decisions he made are still not a basis to show bias. His rulings, his orders are not how you show bias. More concerning is the fact that in December 2024, presiding Judge Lewski enacted Admin Order 2024-47 in response to Mr. Myers' investigative journalism of Superior Court. Oh boy, this is a get. Woo! This admin order expressly dictates that all judges at Pima County Superior Court must follow Rule 122H to the letter of the law. Well, they always do. This makes Judge Metcalf in violation of both Supreme Court Rule 122H and this court's admin order with blatant disregard for the clearly established rules and directives. But once again, I just hate to keep bringing this up, but it is ordered that any use of portable electronic devices, photography, audio recording, or video recording in a courthouse is subject to the authority of any judge, court administrator, or court security officer to limit or terminate activity that may, not is, but may be disruptive to court operations, may, not is, but may affect the fair administration of justice, or that may, not is, but may compromise courthouse security. So the security doesn't have to be compromised before they limit your recording. The fair administration of justice doesn't have to be destroyed before they limit recording. And they don't have to wait for you to disrupt the court proceedings before they limit your right to record. So I don't see that he's violated this rule. He's certain, if he has done it, it's certainly not blatantly, but even let's just say, you know what? Fine, Lane. Fine. He made the wrong order. Fine. I'm going to grant you that, Lane. Just for the sake of argument, I'm going to grant it to you. Still not a basis for recusal. It is expressly not a basis for recusal. You expressly cannot get recusal based on disagreeing with orders that he made. He continues, this takes away from both Mr. Myers' right to a public trial and the rights of a free press. They have a right to be present. They have the same right as the public to be present at a trial or other hearing. They have the same right as the public to be present. They don't have a special right to broadcast or record. They never have. They never will. This is clear bias against Mr. Myers. Well, he said it was clear. Anytime anybody throws in a clear or a clearly or anything that is a synonym for it, you just know that they're just pulling shit out their ass. They don't have an argument. A clear example of this is the fact that several other hearings in this case with other judges, they allowed the use of 122H. They made different orders. Congratulations. March 14th, Judge Hampton allowed 122H recording. March 20th, initial appearance was live on Court's YouTube. All these are live on Court's YouTube that I've seen. Judge Miller allowed 122H recording. Great. April 4th, the court broadcast arraignment on YouTube. Yeah. April 15th, Judge McDonald allowed 122H recording. Great. The fact that other judges allowed 122H recording in the same case causes even more confusion for the press. 122H, just so that everybody remembers, 122H is personal audio recorders. Personal audio recorders. Remember, they must not be obtrusive, distracting, or otherwise prohibited. Okay. Every hearing should allow 122H recording as long as it's not disruptive. Well, there's three things again. Disruptive of court proceedings. It would impact the ability of the court to offer a fair administration of justice, and or it would impact court security. May impact court security. So yeah. Sorry. Number 3, denial of speedy trial. Mr. Myers executed his right to speedy trial when setting a trial date on May 12, 2025. Judge Metcalf set July 22nd, 2025 as a trial date. When told this would not allow enough time to have sentencing within the 150 days, Judge Metcalf said sentencing is not part of speedy trial. This is blatant disregard of Mr. Myers' due process rights under the U.S. and Arizona Constitution as established by case law. What case law? What case law? What one? What case law? What case law? When told of this fact by Mr. Myers, Judge Metcalf said he doesn't care. You can file a motion. Okay. Metcalf said no. It's not part of speedy trial. Myers said it's clearly established case law. And Metcalf said, I don't care. You can file a motion. Okay. Okay. So then he says, okay, yeah. So sure, close enough. I mean, I thought that comports with my memory. He says, a motion for what? Question mark. Well, you're the one who chose to be pro se, homeboy. You're the one who chose to be pro se. Why are you asking a motion for what? You're the fucking attorney in this case. You like to call yourself an attorney because you're pro se. You're the fucking attorney. You tell me what motion. The judge doesn't have to fucking tell you. He's not your attorney. He doesn't have to tell you what motion to file. You're your own attorney, Mr. Pro Se litigant. Too smart for a fucking attorney to represent you. Mr. Myers doesn't need to, quote, file a motion, end quote, to uphold his due process rights and enforce case law. Well, apparently he does, because look what you're doing now, motherfucker. You filed the motion. He says there's a blatant lack of impartiality. No, it's not. It's not. It's not. Quote, in light of the foregoing authorities, we hold that the guarantees to speedy trial found in the Sixth Amendment of the U.S. Constitution, Article 2, Section 24 of the Arizona Constitution apply through sentencing. Let's look it up. That's 179 Ares 109. 179 Ares 109. 179 Ares 109. Google Scholar, case law, select courts, Arizona, done. And it was 179 Ares 109. 179 Ares 109. All right, let's look it up. State versus Burkett. Court of Appeals, Department C. So it says the guarantee for a speedy trial does apply. There's a framework for analyzing it. Barker, Burkett, some other cases. So look at the reasons for the delay, but that's if there is a delay. Interesting. That's interesting because I don't know how to analyze this because they're saying that the Supreme Court said the Arizona Supreme Court said neither this court nor the United States Supreme Court has found the right to a speedy trial extends to sentencing. But then a lower court says it does. So that makes me wonder what the problem is. And I'm not seeing State v. Burkett. It's 93, so sort by date. I don't see Burkett in there anywhere. I'm looking to see how subsequent. I did not click Burkett versus Love. Damn it. It's only one, so that one doesn't deal with it. So it looks like Burkett is still good law, apparently. Sorry. But it's not a hard and fast rule. Like if they start the trial within the 150 days, I still think that at the end of it, he'd have grounds for appeal. Sure, he could appeal his sentencing or whatever, but he's going to have to show that it caused some prejudice or something along those lines. So there you go. That's the way I'm going to go with it. At least within 2 seconds. He only has one case, unless there's something else. And the case that he has doesn't say that he has to get done within 150 days. You know what? I do want to check though. What is the Arizona Constitution section that Burkett was looking at? Sorry for being boring, but I kind of want to know. And you're silly enough to come along for the ride with me And it is, that's where they do the analysis. And Article 2, Section 24 of the Arizona Constitution. Arizona State Constitution. Article 2, Declaration of Rights. Then we're going to go to Section 24, Rights of the Accused, Criminal Procedure. Oh. Yeah, so this Section 24 doesn't say that it has to be done within 150 days. So let's look at the Arizona Rules of Criminal Procedure, Speedy. Westlaw. Share this tab instead. We're going to look at time limits. Westlaw. So the court must try everyone. For 50 days, except as an A3. They may extend time limits in A and C under 8.5. And the court has to set a specific date for the trial. Okay. Okay. And then 8.5. So the court can consider the trial, or sorry, can continue the trial for as long as necessary to serve the interests of justice. But there was that was that one. Okay. Excluded periods. So delays caused by the defendant don't count, or a man for new probable cause wouldn't count. Trial calendar congestion wouldn't count. Continuance granted wouldn't count. Anyway, I guess I'm not gonna go too far into it. Yeah, so the court, so his remedy, Firemoth was right. His remedy, if it's violated, is court dismisses with or without prejudice. So he could just do a retrial. I mean, I don't know. I don't know that he's got any real grounds there. Let's go back to it. But anyway, he hasn't denied speedy trial yet, because he said he's done everything, and maybe it's a one-day trial. You don't know. So on May 12th, when he set a trial date, well, hold on, when he set a May 12th trial date, was Lane out of jail? Because hold on a second. Yeah, he must have been in jail on May 12th. Okay. Anyway. Denial of bail reexamination hearing. Rule 7.4C provides the defendant an opportunity to have a bail eligibility reexamined upon transfer to another court. His case was transferred March 28th. Myers filed a motion for bail reexamination on April 4th. Judge Metcalf was supposed to order bail reexamination hearing within 10 days. He's saying 7.4C. Let's go to 7.4C. Five, 7.4C. Later review. All right. So on motion or on some of the court may examine bill eligibility of conditions of release, yada yada. Doesn't say anything about time for that. All right. Just checking to make sure it didn't say anything about time. All right. Myers filed a motion for bail reexamined on April 4th, 2025. Metcalf was supposed to order bail reexamination hearing within 7 days. I don't know where does it say that? As of April 28th, Metcalf saw an order to bail reexamination hearing, so Myers has counsel withdraw his bail motion, and as counsel, Myers refiled the bail reexamination motion on May 12th. He had to set an evidentiary hearing within 7 days. Again, where does it say that? Seven days. So this is under eligibility for bail. If the motion is by the state and involves a defendant previously held eligible, not ineligible, eligible, it need not allege new material facts. The court must hold a hearing on the record as soon as possible, no later than 7 days. So this has to be read together. This is in section 3. If it was under section 1, where it said it must be held on the record as soon as practical, no later than 7 days, then sure. But the reason for this one is if the defendant is held eligible for bail, meaning he's not within the control of anybody or anything. If the state is going to bring it, the court has to hear it within 7 days, no later than 7 days, because they don't want the defendant to get too far away. If that makes sense. Whoops, share this tab instead. So yeah, you see the only 7 days in here is under C3, but C3 only applies, just on its face, it only applies to motions by the state when the defendant was previously held eligible. This is what he's looking at, section 1. There's no time frame requirements on that. So I think I don't think his argument is very well grounded there, and he has no citation for why the 7 days would apply. He refused to set an evidentiary hearing and set a hearing for oral arguments to decide if he would grant a reexamination hearing. Yeah, that sounds right, because he may, on a motion or on his own motion, he may review eligibility. It's a blatant violation of the rules of procedure. I don't think it is. In established case law, what case law? What case law? Where's the case? Why don't you cite the case law? Denying Mr. Myers' due process right to have his bail eligibility reexamined. Every other defendant in the state of Arizona gets a bond reexamination within 7 days except Mr. Myers. Cite 1. This shows a complete lack of impartiality by Judge Metcalf. Nope, these are decisions he's made that if you don't like, you need to either appeal or file a special action. Mr. Myers is sitting in jail with no bail while Judge Metcalf makes up the rules as he goes. This is eroding public trust in the Pima County Superior Court in front of the whole world. Well, it's kind of weird. This argument that he's making, that number one, that media isn't able to get in there to broadcast this stuff, and they need to. But number two, this stuff is all getting out in front of the whole world, and this is a huge media event. Like, pick one and stick to it. Either the media is being denied access and they need to get access because they're being denied, or the media has access and they're broadcasting this to the entire world. Pick one. Stick to it. Denial of jury questionnaire. On May 12th, Judge Metcalf denied Mr. Myers' request for a jury questionnaire because he found the possibility of the state being prejudiced. Yep. You can't prejudice against the state. But also, I believe the state's argument was that it might direct people to look at the YouTube videos and things like that. He asks, what planet are we on when the judge finds the state can be prejudiced by a possible jury questionnaire? Oh, that planet would be Earth, Lane. You should visit it sometime. It's pretty nice here. If the state wasn't bringing unlawful charges not supported by evidence or facts, they would have nothing to worry about the jury questionnaire. Well, I don't know. So the judge, generally speaking, decides the law. If you believe the charges are unlawful, you should file a motion to dismiss. Oh, wait, you did, and the court didn't find that the charges were unlawful. Evidence gets presented at trial, but the state has already shown by at least a preponderance of evidence, and for some of the charges by God, what is that? I always forget this. By proof evident or presumption great, which is, according to Lane Myers, then attorney at the time, a higher standard of proof than preponderance of the evidence. So evidence has been presented. So there is evidence. There is evidence that is supporting it. Now, whether that evidence will get the state over the beyond a shadow of a doubt, or not beyond a reasonable doubt, beyond a reasonable doubt, that's questionable. That we'll see at trial. But there has been evidence presented. And that evidence has satisfied the two procedural hurdles that the state has faced. The state doesn't claim prejudice when the local news does stories about murder suspects. Sure, but the local news also doesn't do jury questionnaires. So there's a distinction that you obviously missed. The burden of pre-trial publicity rests squarely on the defendant, not the state. Yes, but this is a jury questionnaire. Mr. Myers wants jury questionnaires and does not feel prejudiced if prospective jurors watch his YouTube videos. We know you don't feel prejudiced now, but when you lose, you might. When you lose, you might. The state is worried that they will be exposed for malicious prosecution. The judge, Metcalf, once again showed his favoritism and granted the state's wishes. So the prosecution is not going to be, there's zero malicious prosecution there. They've already proven to a grand jury preponderance of the evidence. They've proven to a judge proof evident, presumption great. So no, there's no way. There would have to be no probable cause, but they've already shown probable cause and proof evident, presumption great. So no, there's no malicious prosecution issue for them. And the prejudice the state was actually worried about was the prejudice against you, Lane. You're just not smart enough to figure it out, that it causes more work for the state if you prejudice everybody against you, and then all of a sudden they can't find an unbiased jury. Now the state's going to have to move out someplace else or risk proceeding with a biased jury and having the jury convict you, and then you filing an appeal and saying, hey, the jury's biased. Well, no shit, Sherlock. The judge should have protected me from a biased jury by not allowing me to do the questionnaire. Although he probably won't, realize it's the questionnaire. My nose itches. It's my cocaine habit. Quote, the burden to show pretrial publicity is presumptively prejudicial, rests with the defendant and is extremely heavy. Right. But that's if the defendant believes that pretrial publicity is presumptively prejudicial. This is a completely different case. The circumstances in this case fall short of those rare and unusual cases where the difficult showing has been made. Therefore, it was extremely biased to deny Mr. Myers the opportunity to send jury questionnaires out. Again, this is another order, and the order can't be the basis of bias. 6, threat of retaliation. Oh, this is onerous work. If I empty this and we're still going, I'm going to get bourbon. Threat of retaliation. During the May 12th, 2025 hearing, Judge Metcalf openly threatened Mr. Myers with retaliation when Mr. Myers indicated he would be filing a complaint with the Judicial Conduct Commission. When Mr. Myers stated, quote, if you don't set an evidentiary hearing within 7 days, you will be intentionally disregarding the law, which is judicial misconduct. Judge Metcalf responded by saying, that's okay, you can file a complaint if you don't like it. Okay, that doesn't sound like he's retaliating. To which Mr. Myers responded, you will be receiving lots of complaints. In response, shockingly, Judge Metcalf replied, quote, don't threaten me. It will not be good for you. Yeah. That's not a threat. That's not a threat. That's not a threat. That is not a threat. Don't threaten me. It won't be good for you. That's not a threat. That is a statement of fact. That is not a threat. Jesus, ever-loving Christ. Again, I apologize about my blasphemy. This is judicial misconduct and requires the immediate removal of Judge Metcalf from this case. I don't think so. Threatening to retaliate. There's no threatening to retaliate. He said, don't threaten me. It will not be good for you. Yeah. Threatening to retaliate for someone putting a judicial conduct complaint is conduct unbecoming a judicial officer. Citation needed. This is completely against the Judicial Code of Conduct and shows the whole world that Mr. Myers cannot get a fair trial with Judge Metcalf. If Judge Metcalf cannot handle public scrutiny, he should resign. The issue there wasn't public scrutiny. It was you threatening to have people send a bunch of judicial complaints in against him. And him saying, it will not be good for you. He's not saying it will be bad for you. He's saying it will not be good for you. It will not be good for you. You won't get the desired result. It will not be good for you. Pants situation? What pants situation? That's what that was my argument. Anyway. So you like, it's not about public scrutiny. He's saying, don't threaten me. It won't be good for you. You could read into that him saying it will be bad for you, but that's not what he said. He said it won't be good for you. If I have bourbon later, it won't be good for me. It won't be bad for me, but it won't be good for me. Rule 1.22 of Code of Judicial Conduct reads, quote, a judge should expect to be the subject of public scrutiny that might be viewed as burdensome if applied to other citizens and must accept the restrictions imposed by the code. Sure, he hasn't violated that. Rule 1.2, subsection 3, Code of Judicial Conduct reads, conduct that compromises or appears to compromise the independence, integrity, and impartiality of a judge undermines public confidence in the judiciary. It does. So if Metcalf buckled to your threat of filing a judicial complaint, that would be the bad thing. That would be the thing that shows that he doesn't have independence, integrity, and impartiality, because he's willing to be bullied and to be threatened into not doing what the law demands. So the very thing that you think exposes him actually shows him not being the thing that you think he is. It's absurd. Rule 2.4, Code of Judicial Conduct. An independent judiciary requires the judge to decide cases according to the law and facts, without regard to whether particular laws for litigants are popular or unpopular with the public, the media, or government officials. Again, that's 100% him saying, look, I don't care if you get a bunch of people to send complaints about me. This won't be good for you. It's not going to help you. It's literally, if all this bullshit that you guys in the I don't know. It isn't actually 1A auditors kind of thing. But it's adjacent to it. It's this sovereign citizen thing, the call flood stuff, where you guys like, everybody call the court, call that judge. He's a real piece of shit. Call that judge. Put up videos about the judge that says the judge is a bad person. We're going to expose him. Blah, 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 right? If the judges buckled to that stuff and changed the way that they did things, that would be a violation of the Code of Judicial Conduct, or could be maybe a violation of the Code of Judicial Conduct. Them not responding to the calls, them not responding to making videos about them not responding to complaints. That is what the Code of Judicial Conduct requires. Clearly, the public confidence cannot be very high in Judge Metcalf when they watch him openly defy the law, rules of procedure, and code of conduct. Well, first of all, he's still publishing that stuff, number one. But number two, he's not changing anything based on the public outcry. Because the public outcry, by the way, is a bunch of Lane Myers supporters that are fucking retarded. So who cares what they have to say? Then, when told that a defendant and the public are going to follow the established procedures and file a complaint, he threatens Mr. Myers with retaliation on the record. No, the Code of Judicial Conduct is not for I disagree with his decisions in court. It's the appropriate thing to do if you disagree with the judge's orders is to file an appeal or file a special action. This kangaroo court is embarrassing the entire Pima County Superior Court and the entire judiciary of the state of California. Blech. In the interest of justice, transparency, and to maintain the integrity of the Pima Superior Court in the eyes of the public trust, Mr. Myers, who apparently has been elected by the public trust to speak for them and to write on their behalf, must be assigned a new judge who will diligently follow all the rules and laws as they are written and as Mr. Myers interprets them. What message does this court want to show the world? They want to show the world that they are going to try defendants in a manner that is as fair and impartial as reasonably possible, considering that we live in an imperfect world. It's time to rebuild the public's confidence in the judges at the Pima County Superior Court. That starts here and now. Elect Pedro or something. I don't know. This is his affidavit. He files his affidavit of facts in support of his Rule 10.1 motion. On May 12th, Metcalf threatened Myers with retaliation in response to possible judicial conduct complaints. He stated that won't be good for you. Sure. On May 12th, he denied a speedy trial by failing to include sentencing in the speedy trial calculation. Debatable. But still, he ordered when the trial would be. That's not bias. Sorry. And just so everybody is aware, if this gets reassigned to a different judge, then that judge, his calendar might be full, and Lane Myers' trial might get pushed out further. Because you got to remember that let's just say this is heard on the 10th. That means that a month prior, the Judge Metcalf set the matter for hearing, for trial, to hit that speedy mark. So if you get a new judge, let's say on the 10th, it gets assigned to a new judge, then that you're going to have to get a hearing in front of that judge. That's probably going to take a couple days. And then that judge is going to have to set a new hearing date, because just because that hearing date was available for Metcalf doesn't mean it's going to be available for the new judge. Then what are you going to do? Got to dismiss it with without prejudice, and have it refiled or something. I don't know. May 12th, Metcalf denied Myers' due process right to bail reexamination here within 7 days. That's mostly a conclusion of law, not a fact, but okay. Throughout the entire proceeding, Metcalf has denied media coverage in violation of Rule 9.3 against Mr. Myers' wishes. 9.3? What is Rule 9.3? Rule 9.3. 9.3. So witnesses can't be in court. They have to be excluded. Spectators must be open to the public, including news media and representatives. This court finds on its own motion, on a motion or its own motion, that open proceedings present a clear and present danger to his right to a fair trial. Record. They must keep a record. Okay, so it is open to the public. That doesn't mean that the news media has to, or that doesn't mean they can record. And whenever the court finds on its motion or on somebody else's motion that having an open court presents a clear and present danger to the right to a fair and impartial fair trial by impartial jury, then it can close it. So it doesn't. Nothing's violated that rule yet. And even if it did, even if you think his order to close the courtroom violated the rule, again, special action or appeal. He's denied the use of Supreme Court Rule 122H. Again, we disagree with that. True and accurate to the best of my knowledge. These facts represent specific allegations and concrete facts, detailing exactly why Metcalf must be removed from his case for cause. Is that how you do an affidavit? Because in California, if you're in California when you sign it, you have to say, I swear under penalty of perjury that the foregoing declaration or affidavit is true and correct. Or if you're outside the state of California, you're filing affidavit or declaration in California, you have to say, I declare under penalty. Oh, if you sign in California and you don't say, if you sign anywhere, you can say, I declare under penalty of perjury under the laws of the state of California that the foregoing is true and correct, and all you have to do is date and sign it. If you just do, I declare under penalty of perjury that the foregoing is true and correct, then you have to state, executed in this place, and that place has to be California, date and signature. It doesn't say under penalty of perjury. I just wonder if it has to be under penalty of perjury. I wonder who wrote the book of love? It wouldn't be the Constitution. It would be what, the ARS, something or the other. Oh, I'm not going to look it up right now. But anyway, it'd be interesting if it doesn't have to say under penalty of perjury. Oh, I do declare. All right. So anyway, that does it for today. Thanks for watching. I hope you enjoyed it. Nobody had the balls to come up here and try to talk shit to my face. I mean, not that would take balls. I'm just basically egging people on a little bit. It would be interesting, to see if one of Lane Meyer's supporters ever did have the gumption to pop up here, show their face, and declare their eternal and undying love for Lane Myers. Will Merb read our questions? Sure. If you ask a question now, I will read your question. Well, I will attempt. I will read it. I don't know if I'll be able to answer it. So just, FYI. If you show Bob and Vagine, then I might do a little bit of background work. Oh no, Lane Meyer's supporters definitely disagree with me. I hate to break it to you, but there is a core of really fucking stupid people who are on the downswing of the bell curve, if you catch my drift, and not on the good side. Have you ever seen anyone else like Lane? Sure. There's a lot of people in this community who are a lot like Lane. I don't want to name any names to give anybody any like street cred, but yeah, there's lots of people in this community. I mean, Lane has he's stupid and fearless, but there's a lot of really shitty people, like stupid people who think they know the law and don't. What's Lane's chance of beating his case? Pretty low. I mean, you know, he recorded himself doing all of this stuff, and he's made admissions in court under oath about this stuff. And I mean, it like I understand Lane Meyer supporters don't understand and can't put together that what Lane did is probably harassment. But your average person, like with 100 IQ, average person can figure that out. I mean, you got a lot of 85 and below IQs in Lane's corner, but the odds of getting those people onto the jury pool are pretty low. Again, you know, first of all, juries tend to screen out people with criminal records. So, and people with criminal records tend to have lower IQs, tend to, hashtag not all. I think California does it by your driver's license. So if you're not able to pass a driver's license test, you know, so it screens out a lot of people. I'm not saying that you have to be that smart to get a driver's license, but you know, the odds of, they tend to get like older retired people tend to be on them. Women who don't have jobs, who are able to do it. Another big subset of jurors, at least in the area I'm in, are people who have really good jobs that they can afford to take time away from, and those tend to be not really stupid people. So I do too. Do you have a blue filter on your PDF viewer or something? I have a nighttime easy on the eyes filter thing that turns on this computer, just to be easier on the eyes and to like help you go to sleep and stuff. And that probably kicked on sometime during this. Okay. Oh, well, thank you. I try to give my honest opinion, and I am semi-educated on it. Well, anyway, Rose Water, I think your name was. You haven't typed a question in here, so let's also, you know, just because I'm feeling generous, I will scroll back to see if I can see a question typed by you. We got Bush. That's not a question. I'm not seeing any questions from Rose Bush, or no, Rose Water or something like that. So anyway, I'm going to call it here. Thanks for watching. Have a wonderful weekend.